The BRICS digital network is a very important initiative that has been started. And I think this conference that was held, which is one of the intermediary rounds in the later workshop that has to come, and I think precisely for two reasons. One is BRICS consists of very diverse countries. And unlike, say, when you look at European Commission or USA or anything, and this diversity makes it very rich at looking at digital markets. And the second thing also that comes up is the emerging markets, so should I say the emerging countries as leaders are in the BRICS area. So it's an extremely important initiative, and I'm so glad to be part of it and to go ahead on it.
The implications of the digital revolution for competition law and policy are going to be quite important. When internet was first commercially used in the 1990s, there was a dream that we'll have a very decentralized and distributed internet connecting peer-to-peer transactions, possibly getting rid of intermediaries and reducing transaction costs. And actually what we have seen the last 20 years, 25 years of development of the internet is the emergence of digital platforms, the centralization of the internet that occurred. These digital platforms are now among the most important companies around the world in terms of capitalization. The top 5 most important companies around the world right now are the 5 digital platforms. We have also seen in China as well the same development with the emergence of a specific ecosystem also with digital platforms there. And I think this centralization is accelerating because of the important concentration of data and the importance of big data and algorithms in the modern economy. These platforms have somehow focused first on core competences in specific areas. Facebook has focused on social media, Google has focused on search, but once they built their specific power in these particular functionalities, they developed to different areas and merged with a number of companies. So we have seen quite a number of mergers with startups. Much of this merger activity hasn't been assessed by the competition authorities because of jurisdictional issues, in particular the focus on turnover, global turnover in Europe or major authorities, and the fact that they haven't really focused on the value of the deal. So we actually ended up having a very centralized global architecture in terms of the internet and its various digital economy applications. Now there is a promise of decentralization. We see the development of blockchain and to a certain extent blockchain, the distributed ledger, promises to bring a more decentralized structure. However, it's still too early to say what could be the implications of blockchain. The same thing about fog computing. We have seen a phase of centralization coming out of cloud computing a few years ago. Now we see the development of fog computing that might lead to a different direction, but again it's too early to say what could be the implications of that. So we do have a market structure which is quite concentrated in a small number of players. That has important implications not only for competition law and policy narrowly defined, but also more generally for our societies, our political system as well, and the effect that this concentration may have on democracy. So we do think that it's quite important to develop a little bit more competition law and policy to take into account these other concerns that this concentration of power brings. in terms of market power, I have to say that we have been focusing too much until now on the concept of market power. However, the development of digital platforms sets new challenges in order to assess power. And power might have very different dimensions. We focus generally on selling power. We focus a little bit less on buyer power. But I think what is really missing is a focus on what has been called by some German colleagues that have finalized a report for the German Ministry of Economics, intermediary power. The power that comes out of the fact that a number of these platforms control very central mechanisms for the transmission of data and information that are essential for the new algorithmic economy. And I think this is a major challenge for our competition law and policy. Digitalization raises important challenges for all economies around the world, and also in particular for BRICS countries. BRICS countries are major economic players. Their GDP has increased drastically the last 10 to 15 years. Some of the BRICS countries now, for instance China and India, are among basically the top 5 economies of the world. So they're very big players. Now, there is a quite important difference among the BRICS countries. Some have managed to develop their own digital ecosystem. China is obviously a prominent example. Others have been less successful in developing their own digital ecosystem. So we have a group of countries which obviously has some commonalities in the sense that they are big consumer markets, and from that perspective they are all affected by concentration coming out of the digital economy. But at the same time, some of them have very active ecosystems, global ecosystems, and some others have capabilities to develop global ecosystems. So from a competition law perspective, it's quite interesting because there is, of course, the focus on consumer well-being and consumer welfare that is somehow common to all competition law systems around the world. But at the same time, because of this developmental perspective that these countries have and these abilities that they have to develop, capabilities that they have to develop their digital ecosystem, there's also a question of using competition law to enable access to the digital value chains, the existing value chains that have been set by the major digital platforms, but also the possibility for them to establish new value chains and new ecosystems that could compete with the global players.
Well, I think the digital revolution brings profound implications to competition law and policy worldwide. It actually requires to think deeper into the dynamics of competition in a much more structured way than we have thought so far. So what we had seen as applying almost to comparative statics, now we need to look at a very dynamic world that's changing very substantially. This makes or poses challenges to professors, academics, and to authorities in reconceptualizing many different aspects of competition law and policy, such as relevant markets, for instance. I mean, we have multiple layers of competition happening within networks and among networks, and we need to look carefully and where are the pockets of competition, how they interact among themselves, and how this will lead to different perspectives in defining relevant markets and assessing market power. Also, I think it leads competition law and policy to rethink about some well-established concepts. So like leveraging or predation, these are concepts that are being rediscussed in a context of the digital revolution. Things that we thought we knew quite well so far are now, they need to have a new reading, a new discussion, and to bring forward new ideas. And also, I think that that's also true for merger review, for instance, where new types of market concentrations are happening. It's not only about restructuring markets in the way that we thought in the past, but it's also about concentration of data. It's about interfaces among different markets, ecosystems, and much broader ways of thinking about consolidation in different markets. So I think all this together poses challenges that are not minor ones. These are really major challenges on new thinking about competition law and policy. I think the digital revolution certainly poses global challenges, and these challenges can be seen sometimes as general challenges that all countries need to face. Sometimes they have peculiarities of certain groups of countries, like the BRICS, and less developed countries, for instance. So you may have peculiarities of groups of countries and some challenges that are very broad challenges worldwide. I think particularly regarding the BRICS, the authorities can cooperate to understand the impact of the digital revolution in economies that are large economies in general, and there are economies that have a large impact of digitization here. And in understanding the digital revolution in the context of these large economies, it's quite important to take a developmental perspective, look on what's the impact of the new technologies on development, and also how these countries participate in the digital revolution. They are not only very large consumer markets, but they are also economies that have the potential to have ecosystems of innovation that are both, to some extent, interrelated to the global ecosystems of innovation, but sometimes they're also local. So understanding how these innovation systems are going to work and how the BRICS countries can actually reconceptualize the way they look at competition for innovation in digital markets, I think it's really a challenge that needs some more thought. So both academics and authorities, policymakers in general, need to develop new thinking to tackle these issues.
Well, I think the problem of the digital revolution perhaps is twofold. There's no doubt about it that the global economy is changing the nature of the way goods and services are produced. So what that basically means is that the nature of the economy has changed, and that raises a profound question as to whether the tools which regulated an economy pre the digital revolution are appropriate for a digital revolution. I'm not sure that they're not. I know that may sound controversial, because when I look, for example, at cases like the recent Google case in the EU, is that really all that different to the Microsoft case of 20 years ago? So one of the things that I think one needs to understand about legal concepts, perhaps it comes from the Austrian Marxist Renner, who took the view that actually concepts remain the same, but the content changes depending on different modes of production. So for me, I think the real challenge is the digital economy means that the content that we give to concepts of competition law no longer apply. So those concepts have to be infused with new content to deal with the digital revolution. And that's actually the key challenge. Now, how do you do that? Well, clearly within a couple of minutes in an interview, I'm not going to be able to do that, even if I could. But the answer, I suppose, is that we've got to start rethinking a whole range of what I'd want to call a normative framework to competition law, which is that the simple idea of consumer welfare as it stands at the moment is inappropriate for this particular kind of economy. And I do think, by the way, that economics, behavioral economics, asymmetrical information, all of those kind of theories, in a sense, render the kind of Chicago economics somewhat redundant. So there is economics that we can borrow from in order to infuse the concepts with new content. The challenges, seems to me, are quite significant because for BRICS countries. Why do I say that? Because two reasons. One is they are less resourced than the developed countries. So you talk to anybody, you take my country, South Africa, we've got very few organizational economists. The competition authorities don't have them. So we don't really have the kind of expertise to give the content that I spoke about earlier. What that basically means is this, that you're going to have to borrow from somewhere. And sometimes it's inappropriate to borrow from the developed world because their demands are entirely different from the developing world. As for the BRICS countries, well, I suppose that, we're supposed to be the odd person out, South Africa, because the idea is that the other ones are all large and we're not very particularly big. But I suppose you could say we represent a range of different countries at the developmental stage, which would not classify fully as developed. What that means for them is how do we now look at the digital economy, which is clearly having an effect, particularly in the capturing of rents away from the national economies and ensuring skewed distribution of wealth through the world. How do these economies which are developing, how do they develop a normative framework, a sense of competition law that makes sense for them and essentially then allows them to deal with the digital economy? That's really why I think any initiative looking at the BRICS countries is such an important feature. As I've said often and say it again, when you're in a position like mine, whereby you have expertise which comes into the country to advise, very often it's expertise from the developed world and has very little linkage with the indigenous needs of developing countries. So that's why the BRICS countries are going to have to puzzle this out for themselves. Not necessarily to reinvent the wheel, but to adapt that which is there for the purposes of their own indigenous developmental needs.
The implications for the digital revolution for competition law and policy are huge. Just like it is a disruptor in markets, it's also a disruptor in policy and regulation. So in other words, we can't do things in the same way that we've done them. We've got to think about, for an example, how do we investigate cases in the context of information now not being there physically but being online, sometimes even being away from your geographic location, your jurisdiction, being on the cloud. You also have to think about the benefits of technology because, of course, it brings a lot of benefits. So you don't want to harm that which it is good for society in the name of regulation, but actually regulation that is backward. So you have to keep up to speed and you must be able to understand these markets and weigh the benefits against whatever may be the harm to competition and markets. The challenges that digitalization brings to BRICS economies are firstly the fact that largely most of these countries don't have these firms that are participating in this market. So issues such as the barriers to entry. So what does it take for local people and firms to enter and sustain themselves in the markets. It's very, very important, because otherwise you are going to continuously have this tension, because the firms that are participating and are seen to be extracting rents are foreign firms. So how do we position our regulations and activities in such a way that they promote entry? The second challenge has to do with how do we regulate these firms. So the firms, as I have indicated, are often not located within the country itself. Now, usually when you have a firm that has committed a transgression, you know their address, you know where to serve papers, and you know who to talk to. Now, here you have firms that are not even registered in the country. They don't pay tax in the country. You have an issue against them. Where do you find them? How do you enforce in such a globalized kind of marketplace is a huge challenge. And also the information, how it is generated, how it is stored. So all of these issues about confidentiality and privacy of information belonging to members of society. And what does it mean for a single firm to have all of this data belonging to individuals and all of societies? Do they have a right to exploit these? What are the implications of this on their market shares, on their market power? What about those who want to compete with them? Can they acquire same data? What are the implications about data sharing? What are the implications for citizens, for individuals? Can this data belonging to them be exploited for the benefit of the company? So these are all challenges we have to try and understand. Most importantly, though, also, is capacity to understand these require that BRICS countries work together. Because no single country, not even in Europe nowadays, can invest enough resources on its own to be able to face up to all of these challenges.
The digital revolution has got complex implications for competition law and policy, and they vary according to the sector and the nature of the products and services that are being sold. So it's very difficult to generalize. But I think in broad terms, it means that the network effects and platforms, which means that groups of consumers that are brought together by services where people want to join a service or a platform, we call it in competition terms, that is large already, those effects are reinforced. So there are very strong first mover advantages, which means that a company in search or e-commerce which moves first gets a large number of users. Other users want to join that same platform because they need to connect to a wider body of people. This means that the first mover tends to have a big advantage. It's difficult for rivals that might actually have better products or services to compete effectively, because part of their offering is the number of members that they have, or the number of people signed up. And so this is a really intrinsic challenge, a really big intrinsic challenge for competition law. In terms of competition policy, I think it raises a number of issues about the need to think about regulation and competition together. So we have almost like a competition enforcement regime of the 20th century and regulation from the 20th century, where you have telecoms separately from finance and payment systems and retail, etc., as discrete, separate regulators. And what digitalization means is that there's the payment system together with telecommunications, logistics, retail. These all become combined inside major corporations. And we need to think about a regulatory regime which actually thinks about managing competition and opening up markets or maintaining markets as open to entrance in that context. The challenges of digitalization for BRICS economies vary quite significantly by the economies within BRICS, by the countries within BRICS. So China has very effectively developed digital platforms, its own digital platforms in the e-commerce or retail space. Similarly, in terms of Industry 4.0, the fourth industrial revolution, they've developed very strong capabilities in terms of things like artificial intelligence, the application of robotics, 3D printing, etc. And that's, I think, a reflection of how their industrial policy has worked, industrial policy in the broad sense, has worked to support local competitors, local rivals. Countries such as South Africa, which is where I'm from and work, are in a very different position. It's a situation where multinationals from other countries are tending to take over these spaces within the South African economy. That's certainly the concern that the government has. And so there's a need to think about how to regulate the market power of these large corporations. BRICS, what I think BRICS countries share is that they are very concerned about the way in which competition law and competition policy can work to support broader industrial development, dealing with inequality internationally. But I think it's a very important and useful collaboration. But the comparative insights that come from the collaboration between BRICS countries are also about the contrasts and learning from differences as opposed to also similarities between them. And I think it's those contrasts that will provide some of the richest insights.
Okay, the implication of a digital revolution competition law is kind of something very profound. And, well, you know that innovation in the current world means a digital economy, and digital economy is currently very important to the economy of every country, in particular for the economic growth. So it's even more important for BRICS countries, because nowadays if all the BRICS countries are developing countries, they want to catch up with developed countries. Innovation is a key in their national strategy. So all the BRICS countries should find a way to improve and strengthen innovation. The competition law in such a process is very, very important. Because why is important? Because we don't really innovation goes, and we don't really know how innovation will end. So for the time being, there are a lot of innovations in the internet world, and they are changing our life fundamentally. For example, sharing economy changing our way to find taxis. So previously we just go to the street and wave our hands to some taxi and stop them. And nowadays we just get a taxi from online. And most importantly, sharing economy is changing our social structure. So previously our society is organized is based on the government. So government always sits in the center for everything, because well, in our traditional social life, the most important thing for social organization is to decrease information asymmetry. Only the government knows all the information. So when we need such a thing from the government needs to grant a license. So our traditional life is license-based. Everybody has a license. The license can be, I'm a professor working for some university, so I receive a license from the Ministry of Education. The taxi driver receive a license from the Ministry of Transportation or something equivalent. But sharing economy changed this thing completely. We don't need a license from some authority, because when we need to know the information of the driver, we just check its previously transactions with other consumers. So in other words, we look at the comments or reviews, so we know the qualification of the drivers. There's no need of such a license. But the thing is that innovation has significantly changed our social structure. It has not been reflected on the legal structure. Our regulation is still adopted in accordance with our traditional logic. That's kind of the very conflict between the traditional business and the digital revolution. But competition law can do its part to solve the problem. Because if we want to import innovation into our legal regulation, we have to completely change our traditional thinking. But competition law do not really look at this kind of logic. Competition only focuses on the competition between different companies. So we have to take full advantage of competition law to make sure that traditional companies and internet companies are competing on an equal footing. The legal challenge raised for BRICS competition authorities and BRICS competition law is something like this. As I just mentioned, all the BRICS countries are developing countries. So when they want to catch up with developed countries, they have to pay a lot of attention to innovation. That is digital economy. But the thing is that no country share the same thought on digital revolution. For example, we have discussed a lot in the recent meetings about data. But what is data? Nobody has consensus on data. Some people argue that we should grant ownership to data, but other people consider that if we grant ownership to data, that would strengthen the market power of data companies. So as we can see, we are confronted with the same problem from digital revolution. However, we don't really share the terminology and we don't share the same legal system in every country. So the BRICS project is very important. It brings all the countries together to share their ideas on the same problem, to bring their own perspectives and see whether we can find a common solution.
There are three aspects regarding the implications of digital economy for competition law and policy that I'd like to mention. So the first one regards the shift from a linear model to multi-sided platforms. And the second is related to the increasing importance of data and algorithms. And the third is the rapid change of things. And why is that so? With the digital economy and particularly multi-sided networks, multi-sided platforms, we have network effects. And with that, we move from a linear growth model to an exponential growth model, which has much faster growth. There are many challenges that the digital economy poses, both for Brazil as well as other BRICS competition authorities. For example, one topic that we have been discussing is the need to change notification thresholds. In Brazil, for example, we have the possibility of analyzing mergers 1 year after the operation has taken place. So far, we didn't find the need, although we haven't. We're still considering if we should change these thresholds. Another point I'd like to mention is the risk of incumbents acquiring startups, for example, and also how to define relevant markets when multi-sided platforms are involved. And another specific aspect that is worth considering is how to prepare to deal with conducts when algorithms are involved. In that sense, I can share CADE's experience with a project called Cerebro, that's the Brain project, where we use algorithms and data to try to find some evidence of cartels. Maybe not evidence, but some signs that cartels might be existing. And finally, how to deal with non-price effects. For example, privacy is nowadays a big concern. And one of the ways CADE, the Brazilian Competition Authority, is dealing with it is taking part in working groups, such as the meeting we had today on the BRICS working group for the digital economy.
I think the implications for competition law and policy are brought mainly by the transformation we're observing in our society and in economy in general. So as you probably aware, competition law was created at the period when paradigm was shifting from, let's say, basically agrarian, feudalic to a certain extent, early capitalist society towards more industrialized era, and that's why competition law was needed to address those challenges society was trying to overcome through this transition. So we clearly at another transitional point, we're clearly observing this transition, and this transition is having like tectonic, systematic nature, and while we have to deal with this through all different means, why wouldn't we try to adjust our competition law and policy tools to address these new challenges brought by digital capitalism, digital revolution, digitalization of the global economy? The main challenges the BRICS authorities are seeing now are related basically to the nature of our economies, and I would use more like term BRICS Plus rather than BRICS, because BRICS is a little bit exclusive form, and we want to be inclusive, so they're basically covering all the emerging and developing countries who are struggling in the same context, in this context of digital transformation, with similar problems, and those problems are related to the necessity to accelerate growth, accelerate development, and make it more sustainable, more inclusive. And as we're turning to the age where digital platforms are basically controlling the ways of production, the ways of consumption, the ways of distribution of economic resources, and digital agents are becoming more and more dependent on controlled ecosystems, walled gardens of economic activities. So developing countries are facing the mainly issue of being in this process, so being involved, included in these activities, because many of those, except China as a very particular case, but which has its own like problems and its featured issues, but except China, which is also to a certain extent is there, but we don't have time to discuss this in more details, but most of the emerging economies are now in a position when they struggling to get included in the process of redistribution of resources in the world economy. And competition authorities have to be at the frontier of this process, because they actually addressing the flows of the market economy. They have to deal with those flows on the daily basis, and they see how small and medium-sized companies, from innovative companies which involved in real R&D intensive research activities, entrepreneurs which are producing new stuff, they innovators in classic sense of this word, but they're struggling to get included in the value chains and global value chains, and as they can't get access to global value chains, their activity basically become useless, even if it's extremely beneficial for the development of global society, global economy, for increasing sustainability, inclusivity of the development of the global economy. So that's why BRICS plus competition, or developing countries, have to be at the frontier of the new paradigm development in competition law and policy.